Hi, everyone. I hope you're doing well. Apologies for the wet hair. I just got out of the shower about 20 minutes ago because it's quite early in the morning for me. But I really hope that you enjoy this lecture. I've prepared a couple of different things to talk about. I'm going to talk about three different institutions in particular. So I'm going to talk about the International Criminal Court. I'll talk about the European Court of Justice, and I'll also talk about the European Court of Human Rights. Each of them serve different kinds of purposes, but they all kind of demonstrate this fundamental tension that exists between national sovereignty and trying to ensure that you have a system of international law that regulates the behavior of states in the way that we need it to in order for the world to be functional and in order for there to be no human rights abuses, etc. Before I move into talking about each of these institutions, I want to generally talk about what international law is about, what its general constraints are, the general themes that we're going to be talking about today, before I move into the more specific and individual cases of the courts that I'm going to discuss and their functions. So, international law suffers from an obvious constraint, which is that it has to be agreed upon by individuals who enter it. And this is definitive of public international law. So, things regarding the rules between states, when states write treaties or when they make agreements with one another. Obviously, there's another sphere of international law, which is just stuff like private international law. So for instance, if you make a contract in the US with someone from Britain, what are the rules that would regulate that? And that's kind of private international law. That's not what we're going to talk about, and that isn't what most people think about when we talk about international law. The international law that we're talking about has states engaging in actions, and there's a fundamental distinction then. States have immense coercive power, and they're able to also resist lots of different court orders, because at the core of it, they're the ones who have the monopoly of force within their territory. And that means that oftentimes international law is not very effective against states who aren't willing, who don't choose to sign a treaty, for instance. And that means that you get a circumstance where courts have to find interesting ways of devising new solutions to deal with these sorts of problems, but also in its general application of the law, it needs to go at a reasonable amount of speed in terms of judicial developments and not go too far. Because, for instance, if you get a circumstance where a court starts enforcing things that countries don't like, those countries will just leave the court. So that's one of the most paradigmatic parts of international law. There's a degree to which national sovereignty is necessary to consider for efficacy as well, because of the fact that these kinds of institutions and bodies require states to buy in to allow for there to be jurisdiction. Part of the reason why is not just a practical reason of being unable to find individuals guilty if you're not able to physically get them from a country, or the issue of countries being unwilling to pay fines, but another one is within the legal infrastructure of the courts themselves. So there's an idea of jurisdiction. And jurisdiction basically denotes what you can or you can't prosecute. Jurisdiction is limited by lots of different things. For instance, jurisdiction can be limited by the fact that you can only prosecute people from countries which have signed up to that court. You might also have other jurisdiction restrictions, like the fact that you must have had a domestic court who heard the trial and heard the case and wasn't able to provide an effective remedy. You might have time limitations, etc. But there are lots of different things that have barriers put up towards international prosecution. And specifically with regards to the question of territory and international law, you get the sort of circumstance in which you have countries who aren't formally within the jurisdiction of the ICC because they haven't signed on to the ICC. And therefore, it's not just a question of practicality. It's a question of whether or not you even have the right as an international legal body to prosecute in the very first case. So when we're thinking about this broader conflict between international law and the national sovereignty of states, it's important to realize that there's a degree to which you need to have compliance. You need to have states who voluntarily sign in because of the legal and practical barriers that exist to prosecution. The final thing that I want to talk about before diving a little bit more into the individual courts, and in terms of the broader thematic issues at play, includes the question of how international law really differs that much from domestic law. And the reason why I want to point this out is because in many ways, domestic law also suffers from the same sorts of drawbacks that you get from international law. Really famous example is Brown and Board of Education. So Brown and Board of Education, for those who don't know, is the landmark US law case, which ends up desegregating schools in the US. As recently as 2015, there was a case against a city in Mississippi called Cleveland, so not Cleveland, Ohio, Cleveland, Mississippi. And in that case, they alleged that that city had not been following the order to desegregate schools within the past 50 years. And that city had basically made it so that schools were still segregated. So they, for instance, ensured that you had this problem wherein different ways of pooling students into certain schools based on their neighborhood predominantly led to African-American students being put into their own school districts. Similarly, they also ensured that when they appointed faculty to different schools, they segregated it so that the predominantly African-American school would get African-American faculty. And the interesting thing about this is that this is a case in which domestic law also requires some degree of recognition by a smaller body that's under its thumb. In this case, it's a federal government having a decision made within the Supreme Court and then trying to compel an individual state to make changes to ensure that they actually follow the rules of that law. Similarly, international law can be seen as a very, very similar instance, wherein you have a large international court who makes decisions that they issue out to individual countries, and countries need to be able to enforce it to a certain degree. The reason why I make this analogy is because I think it's important to note that the differences between international law and domestic law aren't as great as you might initially think. Lots of people think that international law is a fruitless venture, and it's important to note then that it has limitations and constraints like any other form of law, but that there are incentives and different means of trying to bypass those constraints, which allow you to have some degree of efficacy. I'm going to outline those different types of procedures that allow for courts to have efficacy when I talk about the various courts that I've described. So that's kind of the introductory material to help you understand the nature of the issue at hand. Big kind of themes that you're going to see throughout here is whether or not a court is being too invasive, and if it is being too invasive, does this mean that you might get worse outcomes in terms of actually getting prosecution due to jurisdictional issues? And the kind of secondary thematic idea is how you're able to find different clever and subtle ways to try and fix this issue, similar to the way that national courts try and fix this issue. And in the case of the US case that I just mentioned that happened in Cleveland, Mississippi, you had a national court order that the two high schools in the city merge. Obviously, you don't have the exact same power within international courts, but I'm going to demonstrate to you the extent of their power and how they found interesting ways of fixing the issues that currently exist. So, the three different types of courts: ICC, ECJ, European Court of Human Rights. I'll start with the ICC. And before I even talk about anything with regards to the ICC, I just want to mention what the applicability of the ICC is like. So, the ICC is a criminal court. What that means is that it takes individuals and brings them to justice. Unlike the ICJ, which is about ensuring that countries are negotiating and acting properly between one another. So the ICC is concerned about individuals. And specifically, there are 4 different types of crimes that the ICC prosecutes for. They prosecute against war crimes, genocide, crimes against humanity, and the newly added crimes of aggression. A crime of aggression is basically if a state starts an unjustified war. So the remit of the International Criminal Court is to deal with all of these individual issues. And so you see lots of different debates about how exactly you deal with the issue of justice. Do we want a transitional military tribunal within a state, or do we want an independent third-party arbitrator of these sorts of issues? Then you might want the ICC, or look at the ICC as an example or a parallel to use in these sorts of debates. Similarly, in lots of debates, you'll actually get explicit comparisons between the ICC and regional human rights institutions that prosecute individuals. So you, for instance, might see motions about the African Union seceding from the ICC and forming their own state. So generally speaking, this is kind of a useful topic area for the issue of how you deal with transitional justice after revolutions, but also in terms of understanding broader frameworks about debates specifically surrounding the ICC and other courts. So given that it has a very specifically criminal nature in terms of what it focuses on, it also has somewhat more wide-reaching powers than people might imagine. Obviously, you have to be a signatory of the Rome Statute, which is the treaty which establishes the ICC in order for it to have applicability. But the jurisdictional requirements of the ICC are actually a little bit more relaxed than you might imagine. The ICC has the authority to prosecute any individual who is a national of one of the states that have signed on to the Rome Treaty, or prosecute any crimes which occurred on the territory of a nation that signed up to the Rome Treaty. What this looks like in practical effect is you have a circumstance in which, let's say, a country like Nigeria has some kind of civil war breakout. And so it can prosecute, the ICC can prosecute two different types of people within that civil war. It'd be able to prosecute any Nigerian national, so anyone who is actually a Nigerian person by citizenship. And it can also prosecute any individual who does something on the territory of Nigeria. So let's say, for instance, you have someone who isn't a party to the ICC on that territory. You still have the right to prosecute that person, even if they're not from a country which engages with the ICC, but is merely committing a crime within a country that is within the ICC's jurisdiction. So for instance, an American who is in Nigeria commits a war crime would technically then be eligible for ICC prosecution, even though the US has not yet signed on to the ICC and the Rome Statute. Now, this is really, really important because it gives it a little bit more of an expansive power than you might imagine. It basically means that a country who chooses not to sign on to the ICC still has an ability for its individual citizens to be taken into the ICC still if it ever commits a crime on the territory of a country which has signed on to the Rome Treaty. So that's slightly more expansive than people might imagine. But one of the practical difficulties that exists with the ICC is that you'll oftentimes find it difficult to actually get prosecutions because of the fact that individuals just stay in territories where the ICC has no power. So for instance, if someone committed a crime, let's say, Omar al-Bashir, Sudan, has not signed on to the Rome Statute, stays within his own territory, then you're going to get a substantial problem where even if you technically had jurisdiction over him because he committed a crime elsewhere, you aren't able to actually beg the dude and put him into jail or put him in front of a jury because of the fact that you have no power to enter into Sudan and physically grab him. So how exactly then does the ICC end up enforcing its various decisions when it engages with someone who basically hides in a safe zone? Well, usually what you'll end up seeing is extradition forming the majority of the legwork that exists. If you have a country like South Africa, who is a party to the ICC, they have a legal obligation to extradite any person who is under investigation and charged by the ICC if that person comes onto their territory. So a practical example of this is Omar al-Bashir actually did go to South Africa, and South Africa had a duty to extradite Omar al-Bashir to the ICC. Just to clarify, for those who don't know, extradition is just if you send someone over to another prosecuting body if that person has entered into your country. So it's usually a way of ensuring that you have justice done in the correct place. You'll sometimes have extradition treaties enacted because someone has fled to another country when they were wanted in country A. So you oftentimes see people who've committed crimes in the US run off to a place like Britain or Canada or China or whatever to try and avoid being prosecuted. And you might have an extradition treaty that says you have to send that person back to where they came from and where they committed the crime. So extradition is the primary mechanism by which you're going to get some degree of enforcement. But the problem is, in order for extradition to work, you need the extraditing party to actually care about the ICC and its remit and want to enforce it. So in the case of South Africa, they actually got criticized because they did not extradite Omar al-Bashir after Omar al-Bashir had entered into South Africa. And that demonstrates that even though the ICC is trying to find different and novel means of trying to get people on board, and in fact trying to get prosecutions through extradition, it is always bound up by this problem of legitimacy. And this problem of legitimacy is just about whether or not countries think that the ICC is a valid body to use law and to actually apply law and be an administrator of law. So for those who have debated these sorts of motions before, you'll typically see that there's a common argument about bias. And the argument basically goes as follows. The ICC is an unfair institution because it ends up only prosecuting people from the global south, and in particular Africa, which is actually what led to an African Union proposal to withdraw, which did not successfully go through. But it's really important to understand this issue of bias because it affects this question of legitimacy. We've established thus far that some countries don't sign on to the Rome Statute and aren't within the purview of the ICC. But that a way the ICC gets around that is through using extradition treaties to get them sent over. But one of the fundamental problems with those extradition treaties is that if a nation doesn't want to actually abide by the extradition treaty, you have no power at all. And so the question of legitimacy directly ties into whether or not you're willing to abide by these treaties. If you have a legitimate institution, you're more likely to have a country who is willing to extradite because they think the rule of law is fair in this circumstance. Whereas, if you end up thinking that the rule is illegitimate, you as a nation oftentimes feel as if enforcing that law isn't good, or at the very least, you have political cover. So even if it's because you just want to advance your own economic interests, you could say, well, we chose not to extradite person X to the ICC because the ICC is illegitimate and only prosecutes people from these places. So even if the member state is doing it for a political or economic reason, the very fact that an institution is seen as illegitimate allows them to have some degree of political cover, an excuse when they choose not to comply with the demands of the ICC. And so the relevant problem with the ICC is the fact that it's being criticized for being very imperialist and not really focusing on the issues of the rest of the world. There are a few important things to note here that I think can disprove the bias that exists within the ICC. The first thing to point out is that you had tribunals in other parts of the world before the ICC was created, but functionally which served the same role as the ICC. So for instance, you had a big criminal tribunal instituted in Yugoslavia, and it basically followed or was a precursor to the ICC. So even though it wasn't under the ICC technically, it really is the same body who's administrating law, and they chose to focus on a very European issue. The second thing is that in recent years, many more countries have been included in the investigation list for the ICC. So for instance, Georgia, which is an offshoot of Russia, Afghanistan, Myanmar, and Bangladesh for the treatment of the Rohingya people, and Libya. And what this demonstrates is that there's a willingness for the ICC to start expanding past what it traditionally prosecuted. And this means that it's more likely to have legitimacy in the long run, or at the very least, criticisms of the ICC are going to be a lot weaker in the long run as these investigations keep on piling up and they start having prosecutions of individuals who are not within the ICC. The final thing that I want to note about the ICC before I move on to talk about other courts is that the ICC actually gives relatively light sentences. So for lots of these different people who are getting prosecuted for some of the most egregious crimes out there, you have things like 7-year prison sentences. And a lot of the time, you're going to actually have prosecutions which are done after someone has died, so like Gaddafi and Libya. So there's a final and more fundamental question, which is, what is the point of the ICC if it isn't really there to actually institute harsh punishments? And there might be an argument that the ICC is then a body for catharsis, to try and ensure that justice is done, not in the sense of deterring future individuals, but in the sense of ensuring that victims are able to see the justice that has occurred. And this is perhaps a strong reason why the ICC is not a legitimate body. Because if the ICC is not there actually to ensure that you have some kind of positive instrumental effects, but rather is just there to ensure that individuals have a sense of dignity and that victims have a degree of reconciliation and retribution done through all of this process of court procedures, there might be a fair argument for having local or regional courts instead. And the reason why is because regional justice means that justice is done closer to home. It means that the people who have been directly affected are more likely to be able to see the outcomes of that justice and the judicial process that exists. An alternative way to read the ICC and its remit is that even though it doesn't have long prosecution and long deterrence as a consequence, you might get a circumstance in which the ICC is legitimate on the basis that it helps to extract information from people. Although I think that this seems like a tenuous claim, given the fact that oftentimes these investigations are quite lengthy, have already basically netted up everyone that they wanted to get, etc. So it might just be the case that the ICC is there to be a vindication of the norms that exist to ensure that victims feel protected. And in that case, there is a fair argument for regional courts to do the same job so long as they're not corrupt. And then if you can convincingly argue that there's a bias issue that will harm legitimacy, it might be the case that the regional courts, which will be set up in a counterfactual world, are the only possible courts that could be effective. So that's everything on the ICC, describing how the ICC functions, the various constraints that it faces, all the issues about legitimacy, etc. I hope that it's useful. And again, this is most useful in any debate about how you deal with transitional justice or specific debates about the trade-off between various courts. And of course, the ICC is only applicable in countries which have signed the Rome Statute, and they enforce this through extraditions when an individual has fled to a member state or a nation that hasn't actually signed on to the Rome Statute or hasn't ratified it. Okay, so moving on then, the second thing that I want to talk about is the ECJ. And the reason why the ECJ is relevant is because it's just useful for almost any EU debate motion. For instance, Euros last year, there's a debate about qualified majority voting. And obviously that isn't directly related to the ECJ, but you can see that there are obviously similarities, because if you can understand the proper decision-making procedure and what's approved by the ECJ, then it helps you to guide and understand what QMV will actually allow you to pass. So to give you a brief overview then of what the EU does with the ECJ, the ECJ is limited by a set of competencies. And what competencies are basically what's signed in the treaty. So every single member state says that we will comply with the EU, but it's not just we'll comply with every single decision made by the EU. The treaties specifically designate different areas or different issues that the ECJ has jurisdiction over. So for instance, trade policy is an obvious thing that we all know the EU has control over, and therefore the ECJ can rule whether or not national courts are compliant with the trade policy rules formed by the EU as a whole. So this is the basic kind of understanding of what the ECJ has control over. It has control over obviously any member state within the EU, but more importantly, it has control over the subject matter of things that have been put into the treaties, and therefore there are some realistic limitations on its ability to legislate. And the reason why it's so important that there are some restrictions on competencies is because it means that you deal with this problem of legitimacy a little bit more effectively. If the EU is only ever legislating on things that are within its remit, and the ECJ is only thus making sure that it enforces these sorts of things through the treaty competencies as a way of ensuring that you don't overstep your boundaries, member states are a lot less likely to leave. So something that I should have mentioned with the ICC, for instance, but the ICC actually had Burundi leave because of the fact that it had very little legitimacy. With the EU, it's a little bit more tenuous that the ECJ is the thing that encouraged Britain to leave. In fact, it's probably other kinds of things that really fueled that kind of sentiment, including false information, populism, etc. And so I think it's important to note that the ECJ has already created some degree of judicial self-restraint by limiting it itself to the competencies of the treaty. I'll describe what those competencies are in a moment, but the basic idea is that every state within the EU has to some extent signed up to what the ECJ now governs, and that helps to ensure that you don't have countries leaving willy-nilly, and that you have countries who are willing to buy into the system. So a little bit more detail on the ECJ and how it functions and what it exactly does. The ECJ primarily ensures that the legislation passed by the EU is legitimate, or that member states are complying with any of the legislation passed by the EU. So if, for instance, you have a rule set out by the EU through the European Parliament and the European Council approving a piece of legislation, if a member state doesn't enact it faithfully, then the ECJ can have a ruling on it and say that whatever action taken by that member state is incompatible with the law that has been passed by the EU. Now, this reaches into a classic dilemma, which is how exactly do you get enforcement of international law, and how do you have any degree of influence? And with the ECJ, they actually came up with one of the most clever solutions to the problem that exists. In the EU, there's this doctrine called direct effect. And what direct effect basically means is that if the ECJ makes a binding ruling, the national courts are required to comply with that ruling so long as the conditions of the legislation are clear, precise, and unconditional. Very technically, you'll actually have this effect where direct effect matters regardless of an ECJ ruling. So if the EU passes some kind of legislation and the European Council approves it, then that automatically is something which has direct effect. And what direct effect does is it forces national courts to apply the law of the EU. So instead of requiring something like the government of Britain or France or some other member state of the EU to comply with certain decisions and implement those decisions, the EU has created this kind of doctrinal novelty through the ECJ, and now national courts directly affect and directly apply EU law. This is really useful because one of the biggest problems that exists usually is that governments are bodies which have political interests that are oftentimes oppositional to larger scale courts at a global level. But if you implement this through national courts, there isn't any of that bias problem which exists because national courts aren't politically motivated actors. And if it becomes just part of the framework of that country, it's just something that they start to implement, then you get this scenario where EU law has deep penetration into all the various facets of national law and ensures that it can actually pass different policies in a much more effective manner because it doesn't need to negotiate with individual governments, rather allow the rule of law and the constitutional setting of each individual member state dictate this sort of enforcement. So that's really powerful. It basically means that every national court is now a court of EU law as well, that they're a court of first instance for the ECJ because they are obliged to apply EU law. This is also a huge reason why you see large-scale reforms that are possible through the EU. So let me give you some example of different kinds of cases that have come out, which have been really important and have been really instrumental for a lot of the classic EU debate issues that we talk about. So one really interesting part of EU law is its approach to human rights and fundamental rights. And basically, the EU has some very strict fundamental rights that are put in place within the charter that they've created of fundamental rights in Europe. But also you get this kind of effect where you have the EU protecting lots of rights through directives, through regulations, other sorts of forms of primary legislation, which the treaty has said that they're competent to deal with. So a good example of this is in this case called Commission in Poland. In Commission in Poland, you had Poland try and replace all of their justices within the courts, so their judges within the courts, at one time by lowering the retirement age. And the plan of Poland was to basically put in a bunch of judges who are favorable to the Law and Justice Party, which is the ruling party in Poland, and basically to stack the courts. And so the ECJ actually made this ruling, which had to be affected directly. So national courts started to implement it. But the ruling that the ECJ made was that it was illegal under EU law for Poland to replace all of its judges because it would contravene some of its fundamental values in terms of judicial independence and judicial effectiveness. And therefore, Poland wasn't allowed to turn over their entire set of judges based on reducing the retirement age. And what this is really powerful in terms of showing is that there are other mechanisms of trying to force compliance to human rights standards within the EU. So you might get all these debates about why you should be, I don't know, maybe ejecting countries like Hungary or Poland or introducing countries who have human rights violations. An important thing to observe is that in many ways, the very structure of EU law allows for some types of reforms to be passed, and not by going through the politically biased actor of the government, but through the more politically neutral actor of the courts of a state. This means that you have a powerful effect of at least ensuring that countries don't get worse if they enter into the EU and have to comply with the ECJ. But you also might get the positive effect of countries becoming actively better because other provisions on fundamental rights like data protection, the right to be forgotten, and the general data protection regulation, those sorts of things will bind individual member states and maybe encourage their human rights in some aspects to actually become better and more expansive. Another good example of places where the EU has done really good work, non-discrimination is another right that has been affected. So there have been cases like this case called Mangold, where age discrimination was prohibited by the EU. You also see lots of things like regulation of labor. So things like the maximum amount of time that you can force someone to work in a week, unless they voluntarily consent to working more hours. There's a whole set of things that are quite progressive that the EU has passed with regards to rights and with regards to labor protections. So that's really important to recognize because any country within the EU has significant protections that way. And that is one reason why being in the EU is so great. One reason why Brexit is a really big loss for individuals within Britain, not just because it means that you have less economic integration, but because the human rights standards which are enforced become domestic rather than also integrating the quite strict requirements of the ECJ. Although it also depends on whether or not you think the ECJ makes correct rulings. Okay, so one area of EU competence and what it deals with is fundamental rights, labor protections, all this kind of stuff that we love as left-leaning debaters. There are some other things that OSCE has control over. It obviously has control over trade policies, and it does so in a very, very sophisticated way. It actually scrutinizes all measures that an individual state makes, which can impede market access. What this basically means is that if a country, for instance, makes this sort of decision to, I don't know, ban jet skis in most waterways of their country, they might be found in violation of EU law because they have practically prevented the import of jet skis into the country because they've made it so no one wants to use jet skis, so why buy jet skis? This means that you oftentimes get this effect of the EU and ECJ quite invasively ensuring that you have free trade between countries and it prohibiting all measures equivalent to quantitative restriction. It doesn't even care whether or not a policy is particularly discriminatory to imports or exports. It only cares if the effect of it is such that it leads to diminishing market access. And the only kind of exception to this is with regards to things like advertising or how you sell a product. So for instance, if you don't have trade on Sundays because you're a religious country, that will now typically be protected by the EU. You won't have to lift that restriction because it impedes market access, as that's a legitimate goal of the individual state. And importantly enough, you also have this market access reason, or sorry, importantly enough, you also have this sort of selling arrangement circumstance where you're not really affecting any product, you're just affecting how products are sold generally. Another thing to note about this whole line of cases about trade is even if you're found to have some type of restriction on trade, if you can justify it on the grounds of something like public health or whatever, you actually are allowed to not overrule, but to circumvent particular EU legislation on that issue. So if, for instance, you have some kind of pressing public health need, like preventing disease or pandemic, and therefore you stop importing from a particular country, that's completely fine and it's justified. What I think this line of cases about trade seems to indicate with respect to the EU is that there's both a degree to which the EU is quite invasive and ends up imposing its authority quite expansively in a way that might threaten legitimacy and might cause countries to want to secede. But also the fact that there are some justifications which are available for member states to restrict trade means that you get this kind of circumstance where you have an equilibrium where member states aren't too offended because they can always prove any restriction is legitimate and valid. The last set of circumstances in which the ECJ ends up legislating and ends up affecting things is an immigration and free movement. And here it's quite expansive because obviously everyone knows that there's free movement of workers and people within the EU under the status quo. But this has been interpreted a lot more widely than one might imagine. So now the law on free movement of workers and free, and also, you know, the provision of services, free establishment, all that kind of stuff, the law has made it so that there's more expansive protection of spouses now. So there's this case called Mary Carpenter, where a woman from the Philippines is married to this guy in Britain. And this guy in Britain sometimes does trade with other people in other EU nations. This woman, Mary Carpenter, ends up being deported. And the ECJ says that this deportation is not lawful because if she leaves, she can't take care of their child anymore. And that the husband, who is an EU worker and provides services across borders, would then be forced to move as well, or take care of the child and then not be able to properly perform his functions in his job. And so basically the ruling by the ECJ is that if you deport this woman, Mary Carpenter, you prevent this guy from exercising his freedoms as a worker. He can't establish services across borders. He can't exercise free movement to go into different places to negotiate and conduct business. And therefore you end up protecting that wife. This has also been used to protect parents of a child. So for instance, you have cases where two Chinese immigrants come over to the UK. They have a child in the UK specifically to give their child UK citizenship, and then as a consequence, EU citizenship. And you have the ECJ rule that you can't deport those parents because that would hurt that citizen, the daughter or the son's prospects of being able to enjoy their union citizenship. So you can see that there are also wide-reaching effects wherein the protection of free movement of workers and also the protection of the rights of union citizens will oftentimes lead to expansive immigration policy where you're not allowed to deport people anymore so long as they're sufficiently tied to an individual who has legitimate interests in the EU. This is, I think, a pretty wide doctrinal novelty of the EU, and it is something which probably leans against its legitimacy because it's control over immigration policy in ways that don't seem to be immediately connected to the EU treaties. At the same time, there hasn't been that much judicial discontent about applying these rulings, and countries haven't really made movements based on these individual rulings that I just described. So it doesn't seem to be that significant of a threat. And then in terms of why it might be positive and might be a good illustration for any debate round, is that it helps to demonstrate how exactly the EU is quite progressive on a lot of these different issues. And if you're in favor of the idea that your birthplace is arbitrary, etc., then you can use the ECJ as a mechanism to try and affect it, or even as an illustration as to how it's done, and even just in terms of generally discussing the merits of the EU and how it functions. So that's a set of different things about the EU. I'm going to quickly refresh this page about questions to see if any questions have come in during the middle of this session. And if not, then I'll move into talking about the European Court of Human Rights. Okay, great. And just as a bottom line summary then of the ECJ only binds EU member states. It binds EU member states on the issues that it has competency over, so things which have been agreed to by those member states. It enforces primarily three types of big things that are useful to understand debate rounds. It enforces immigration policy, enforces economic policy in terms of reducing barriers to trade, and it also enforces fundamental rights and protections. And the unique thing about how the ECJ enforces its policy is that it makes this doctrine of direct effect so that national courts are obliged to follow the law of the ECJ and to apply that law rather than having to go through the politically motivated actor of the government. So this is an example of a circumstance in which, again, the courts have found some kind of sneaky way in order to enforce its own law, even though traditionally it would have to bind the individual member state through its government. It instead chooses to do this through the solution of courts taking the lead, much like how the ICC uses extradition as a mechanism to try and bypass some of the practical issues that exist with capturing people who are in states that aren't members or aren't signatories of the Rome Statute. Okay, the final kind of court to describe is the European Court of Human Rights. And as you might imagine, the European Court of Human Rights is designed to protect human rights. It, again, is bound to only prosecuting the states that are within its jurisdiction. So states which have signed the Convention on European rights. It's really important to note the Charter of Fundamental Rights is going to be an EU construct, whereas the Convention is the European Court of Human Rights, which is governed by the Council of Europe, and that's a completely different body from the EU. So these are two separate bodies, although there's a lot of overlap, and most EU nations, I think actually almost all of them, are members of the European Court of Human Rights, although there's some members of the European Court of Human Rights, like Turkey, who aren't members of the ECJ because they're not part of the EU. So these are two separate courts. They sometimes have overlap, but it's important to note that they are separate and there are different countries involved in each. So with the European Court of Human Rights, obviously they're concerned with protecting human rights. There are a couple of things I want to talk about in terms of the European Court of Human Rights, which I think are useful for debate rounds. The first thing that's useful for debate rounds and understanding the European Court of Human Rights and how it functions is how it enforces its rulings. And primarily what ends up happening is individual member states of the court of the Council of Europe will end up having an application filed through an individual who is complaining of behavior. So for instance, you might have someone who's complaining of discrimination by the state. You have that case heard by the European Court of Human Rights, and the European Court of Human Rights typically imposes a fine that the individual member state has to pay to the aggrieved applicant. So a really easy illustration of this, there's this case called Smith in UK, which is a case from the late 90s, early 2000s. It's basically a man who is dismissed from the military in the UK because he's gay. He ends up taking this to the European Court of Human Rights. The European Court of Human Rights decides that the action taken by the UK to not allow homosexual members of the military is unlawful under the human rights legislation that exists in the convention, and therefore the UK has to pay a big fine to Smith, who is the homosexual man who was dismissed from the military. So the mechanism of enforcement is actually a lot weaker through the European Court of Human Rights, because very technically, a state could say, well, we don't really want to pay out this fine. It's important to note that most countries do pay out the fine, but there is no concrete legal mechanism or way of bypassing it like you've seen with the ICC or with the European Court of Justice. Rather, I think you have this kind of circumstance in which courts follow you have the circumstance where national governments end up following the European Court of Human Rights and their decisions for two reasons. First, because politically it looks really, really bad if you end up not doing so. One of the big functions of courts, both domestic and international, is through its signaling to the public of certain issues which are acceptable or not. So, for instance, the decision of Brown and Board of Education, while it did not lead to immediate desegregation everywhere, had a very powerful political message that it ended up putting forward, because this then meant that political lobbyist groups were able to capture this kind of ruling and leverage it. But you also just had a general momentum for that movement because you had success in the judiciary. So sometimes there are strong political reasons that these kinds of decisions do get enforced. It creates political momentum for a cause. It becomes really hard not to enforce that ruling if you've created this political momentum for desegregation, and therefore most bodies start to feel pressured into administering this policy. Similar logic applies to the European Court of Human Rights, where being found in violation of a human right is pretty bad. And if you don't comply, you'll get a lot of scrutiny placed upon you as a national government. So the informal mechanism of political pressure will oftentimes be enough to get some degree of change and compliance with international courts. A secondary thing that is useful is that with the European Court of Human Rights, you kind of have a quid pro quo to a certain extent, because sometimes you might have a different member state attacking people. So you might have a different country who is a part of the Council of Europe and who is subject to the jurisdiction of the European Court of Human Rights, attacking people from your own country. So for instance, you have this case of Turkey occupying Cyprus throughout history. And the European Court of Human Rights will actually be able to prosecute in those cases and say that Turkey wronged Cyprus, and therefore there might be some compensation that Turkey has to pay Cyprus. And so lots of countries feel like they should be upholding the European Court of Human Rights, because even if they're being unfairly punished now, or unfairly punished now, even if they're being punished now, they have a reason to comply, because compliance creates this general norm of all countries sticking to the European Court of Human Rights. And so if a country gets screwed over by another country, then they'll have protection as well. So it's kind of a quid pro quo where country A will comply with the decisions of the European Court of Human Rights, because if it's ever wronged by country B, then that norm will mean that country B pays out country A. So there are two kind of indirect then mechanisms that you get from the European Court of Human Rights, which apply some degree of pressure. These can also be reasons why you might get domestic courts applying rulings as well, primarily through the mechanism of political pressure and political compliance, as well as the mechanism of a quid pro quo and some degree of agreement in which you trade political favors. Just for reference, I think this is quite a useful argument in different rounds about the ICC, because this can link back to the whole idea of trust a lot more. So the reason why you're more willing to, for instance, have extraditions within regional human rights courts would be that you think that there's a quid pro quo. because in these kinds of circumstances, you typically have fugitives who committed war crimes in the global south immigrating to other countries within the global south. So you have people like Charles Taylor going to Nigeria. And so the fact that you're able to have some degree of extradition enforced in that case means that you're willing to also extradite your own war criminals. Whereas in the context of the ICC, you don't really get that trade of favors, because it's not like the West is typically extraditing African war criminals back to the ICC so that African states can get justice. Rather, it's African states who are always negotiating with one another with their extradition treaties and having to trade something, whereas the West almost never participates in that, and therefore gets all the benefits of international conviction through their imperialist system, but never have to bear the burdens of also engaging in extradition. So this whole idea of mutual trust and quid pro quo is also relevant and important for being able to decide whether or not the ICC is effective and whether or not regional human rights courts would be more effective, because it notes that the quid pro quo only happens between some countries. Before moving on, I just got a question. So the question is it possible for member states or the entry of new member states to change courts internally or undermine them? This is a great question. So it's important to understand how these courts operate. The introduction of new member states doesn't change the procedure of the court. The court will still have the same judges, all of that kind of stuff. But sometimes it can change the substance of rulings. So in the European Court of Human Rights, there's this concept called the margin of appreciation. And the margin of appreciation is basically this idea that we will give national governments and decision makers more space for making decisions as long as it's something that is controversial. So for instance, on issues of morality, you won't have much consensus on whether or not you should restrict certain offensive images, because of the fact that lots of states have different standards of morality, and therefore they will oftentimes enforce it in different ways. And so the European Court of Human Rights in these sorts of cases says, look, we're not qualified to deal with these issues because member states don't agree about what the correct thing to do is. You know, the individual states within the Council of Europe have no consensus about what's happening. The reason why this is relevant is because if you admitted a bunch of really illiberal states to the European Court of Human Rights, you might get a circumstance in which it has less powerful human rights protection. Because if, for instance, all the previous states within the European Court of Human Rights decided gay marriage was something that ought to be protected, if you got really illiberal states coming in, you don't have a consensus on gay marriage anymore. And therefore, the court might be more willing to say, well, this is a moral issue, which isn't a fundamental right that we can protect, because member states have differences in opinion. So that's one way in which you get this kind of dilution of human rights protection, because necessarily, if you remember the central tension I talked about, there's an issue between national authority and national sovereignty against the authority of these kinds. So you have national sovereignty against global authority through these international courts. And so these courts are always trying to find different ways to restrain themselves so that countries don't leave. Part of the thing here then is that you get the circumstance in which national courts are going to influence global and regional courts precisely because of the fact that they have introduced these sorts of doctrines in order to mitigate and reduce their ability to have wide-reaching and invasive judicial rulings that will turn countries off. This example of Turkey, so for the ECJ, it's a little bit less clear. The ECJ doesn't really have the margin of appreciation as a specific concept. They do have an idea of subsidiarity, which is you should be delegating tasks to member states when it's appropriate for them to do so, but it doesn't really affect them in the same way that does for the European Court of Human Rights. And Turkey's already in the European Court of Human Rights. So admitting Turkey into the ECJ, I would say, is less likely to undermine those courts, because those courts don't end up considering consensus as explicitly in the ECJ. I hope that makes sense. Okay, cool. So just to finish off this discussion about the European Court of Human Rights, I've already pointed out the whole issue of how they enforce things and all the issues of political enforcement and how political pressure can deal with things. A secondary thing to understand is that human rights law has significantly different types of law and different types of rights that they protect. So you have rights like the right against torture, which is absolute. You can never justify torture as a member state of the European Court of Human Rights. The more formal term is a high contracting party, but I use those terms interchangeably. So you can never justify something like abuse of torture, you can justify something like a restriction on free speech. And that's kind of a distinction between absolute and qualified rights. And it's really important actually that you have this kind of distinction and understand this distinction for debate rounds, because it helps you to understand to what extent human rights courts actually infringe on sovereignty. So they infringe on sovereignty most strongly when there's a right that is being deprived, which is fundamental to someone's dignity, but they're less likely to be invasive and intrusive of sovereignty whenever you get a circumstance in which you have a right that is very loose or isn't that fundamental. And the third thing that I want to talk about in terms of rights is just kind of different contexts for rights and understanding rights in a more specific way, in a way that will be useful for debate rounds. So the first type of right that I want to talk about is the right to equality, which the European Court of Human Rights enforces. And the thing that I just want to point out here is that in equality law, and specifically non-discrimination law, it becomes very difficult to be able to tell in what circumstances there's been discrimination. So for instance, in early times of discrimination law, you had cases where a pregnant woman who wasn't hired was not found to be discriminated against because she was being compared to no one else. There was no man who was pregnant. And if you couldn't prove that you were being treated worse than someone else who has equal status other than the characteristic that you're being discriminated against for, then you don't have discrimination because you aren't treating someone worse than some other person. So there's this new concept called indirect discrimination, which is now implemented within the ECH, the European Court of Human Rights, but also is in US law and is called disparate impact. And this is really useful for a lot of debate rounds. So basically what happens under the idea of indirect discrimination is whenever you can find that there's a statistically significant difference between two different groups. So for instance, it is overwhelmingly the case that Roma children are put into a worse classroom within Croatia, which is a real case that happened. In those kinds of circumstances, you're going to have an inference that there is discrimination because of the fact that statistically you see that not enough children are being put into classrooms that are equal in strength, or not enough women are being put into workplaces, whatever. And then it is on the individual country to prove that they aren't being discriminatory. So the burden of proof gets flipped in these kinds of circumstances. This is really useful because I think there are lots of debates which are like workplace. So there are debates about discrimination, and lots of people in reference to debates about workplace discrimination might say it's really hard to catch workplace discrimination because in any individual decision that is being made, you'll always have an excuse that someone just wasn't qualified enough. And therefore there was no discrimination. You were just making a decision based on their qualifications. If you expand the test of indirect discrimination, or disparate impact as it's called in the US, you can't have that defense from employers. Employers need to do more than just to say we are evaluating on merit. They need to demonstrate that this was a legitimate and valid ground that can stand scrutiny, even when the burden of proof is flipped onto them. So this is just useful for understanding lots of debates about equality and also for just debates about discrimination. There are mechanisms to be able to deal with discrimination, even in the cases where discrimination is quite subtle. And in the groundbreaking case in the US, Duke and Greg's Power Company, you actually had protection of minority rights in the workplace. So African Americans were being denied employment at a regional factory. And through the doctrine of disparate impact and indirect discrimination, these individuals found redress for the problem that existed. A separate thing that I want to talk about in terms of a specific right with human rights courts is the right to private life. And what I'm going to illustrate with this right is just the point that there are some flaws with human rights courts because they're quite expansive in their interpretation of what a right is. And therefore, even though we always think human rights courts fantastic, it can oftentimes end up protecting things which are quite problematic. So there's this case called Hatton in UK. And basically, it was a complaint against the construction of another terminal at Heathrow. And the complaint was on the basis that it would disrupt the sleep of people nearby. So this is determined to be a violation of the right to privacy, because if you do construct that airport runway, then you do end up getting a disruption to someone's right to sleep at night, and that is part of someone's private life. At the end of the day, the European Court of Human Rights ends up deciding that it's been justified, that the runway construction is justified and matters more than someone's right to sleep. But the idea is human rights are oftentimes very vague, and human rights courts have a tendency to expand them and find that they're worthy of protection, at least on a prima facie basis, much more than you might suspect. This is also why things like offensive speech can be protected under Article 9, which is about free expression. Sorry, Article 10. So this is also why you might get offensive speech protected under Article 10, though, and also why you might get some kinds of interests which don't seem to fall under the purview of rights being protected. So a really famous piece of commentary is lots of people say that the European Court of Human Rights doesn't treat free expression very well because theoretically sports commentary, pornographic speech, and political speech are all things that fall under the right to free expression and ought to be protected, at least on a prima facie basis. And so human rights courts can be slightly more problematic than you might imagine because they oftentimes take expansive views of rights in a way that might actually violate minority groups and their dignity, or in a way that ends up infringing on sovereignty in quite a wide-reaching way because it thinks lots of things end up being violations of human rights, even though that is a seemingly strained interpretation of the right at hand. Okay, great. So that's the European Court of Human Rights. Big takeaways from the European Court of Human Rights. First of all, the very specific way in which it enforces its policies and decisions through political pressure and through mechanisms that are more informal. Second of all, the divide between absolute and qualified rights. So the infringements on sovereignty are not as great as you might think initially because you can justify infringements on human rights on certain grounds. And lastly, this discussion about the different types of rights and using that as a concrete illustration of particular things which are useful in debate. So in the context of equality law, the idea of indirect discrimination ensures that you have less discrimination because of the fact that you flip the burden of proof on a party. And then with respect to privacy and free expression, an illustration as to how human rights are oftentimes expansive with their definition of what a right is, thus meaning that you oftentimes have greater incursions onto national sovereignty than you might expect. The final and concluding remark that I'm going to make here, and I didn't want to talk about it too much, but I did want to bring it up, was on separatism, the right to self-determination, etc. So I'm not going to talk about the underlying principles too much here because I think that that is kind of a separate issue altogether. But one thing that I think is always useful for a self-determination debate is an understanding of what self-determination ends up entailing. And specifically, it entails these small territories which have been oppressed getting the right to create law and enforce things within their own territory. And so a really interesting example is that of Iraqi Kurdistan. Iraqi Kurdistan has partially independent status within Iraq as a whole. It has its own constitution, it has its own administration of lots of different policies, and it functionally has control over a set area of territory. One thing that I learned actually from doing a comparative analysis of the constitutions of Iraq and Kurdistan is that Iraqi Kurdistan has less protections for minority rights, actually acknowledges less minority groups. So it doesn't recognize as many Christian groups. And in practice, it actually discriminates against Christians and Catholics a lot more than Iraq does. So one thing to pick up on in international law is that oftentimes with separatist movements, they end up being discriminatory to minorities within their territories as well. And oftentimes that's enshrined legally by the fact that their constitution does not recognize certain religions or certain groups. So this is an interesting dynamic of the separatism debate. It's somewhat related to international law, but I think it's more so illustrated by the fact that constitutions don't protect certain minority groups in Iraqi Kurdistan. And more prominently, this demonstrates that there's a lack of respect for other minority groups within separatist movements and when groups end up seceding from a country. So that just might be a useful thing to add into the secessionist debate and a good illustration as to how they don't respect minority rights within the territory of a separatist state. Okay, fantastic. Thanks so much for listening. That takes me to the end of an hour, and I hope that was useful. Big takeaways. There are different types of enforcement that these courts try to use to protect rights. Oh, okay, I will pull up that new question. Okay, fantastic. Really cool question. So would disparate impact apply to the US's criminal justice system being discriminatory, or does that not work since it is a state body? This is an awesome question. So the issue with all law is that you always have these sets of cases and you need to expand precedent and place it somewhere else. So say, for instance, this doctrine of indirect discrimination, which we applied to schools or we applied to working in factory, we're now going to see if we can apply it to some other aspect of the government or of the judicial system or whatever, and see if we can find ruling. So it's the expansion of precedent. Now, in the case of criminal justice, I'm actually not aware of any cases in which criminal justice has been litigated on with a indirect discrimination justification. What I would intuit is that in these cases, they would end up concluding that individual courts have done a good enough job that justified the decisions that were being made. So as long as a court was being procedurally sound, they had followed all the correct directions, they had applied the law correctly, there would probably be a discharging of that burden of proof, because the the US would then say, well, look, there are valid reasons why people are being placed into these systems, into the prison system, and as a consequence, our decision is justified. And then from the YouTube stream, what are the most common reasons for states to pull out of international or regional courts? Primary reason that you'll oftentimes see is self-interest. So members of the political system in that country do not want to be prosecuted. So you actually saw Kenya a few years ago suggest pulling out of the ICC because Kenyatta was being prosecuted by the ICC. So sometimes you'll end up seeing really personally motivated decisions. If you're talking about a broader scale, past just like personal interest, corruption, and nepotism, I would say that most states would pull out of international regional courts, like the European Court of Human Rights, primarily because it ends up feeling like those decisions are unfair. So it thinks that their national sovereignty is being infringed upon. So there's this really famous case called Lazzi in Italy, which is about the right to hang crosses within educational buildings in Italy. And what ends up happening is the European Court of Human Rights says, Italy, you're not allowed to do that. That's not a secular policy. Italy, and I think like 15 other states end up being furious about this, immediately file an appeal. And so the European Court of Human Rights steps back on its decision because they take this case to an appeals court, the Grand Chamber, and they end up deciding, actually, Italy, it's okay that you maintain that cross. And I suspect the reason why the European Court of Human Rights did so is partially because they're afraid of member states leaving if they ended up enforcing such a strong restriction on religious rights within those territories. So almost always it's going to be a political reason, whether it's an individual who's being prosecuted in like the ICC or just a general political policy that is meant to be enforced. Okay, I have another question in the Zoom chat, so I'll also answer this one. So the question is, in practice, are state complaints against other states which are not related to war crimes, A, actually filed in the first place, and B, successful? So state complaints against other states which are not related to war crimes do end up being successful in some circumstances. So the cases where Turkey has occupied other countries has typically led to a finding of liability on, usually Article 2 grounds of the European Court of Human Rights, which is the right to life. So you end up killing people, that ends up being a big problem. So yes, you do see these things being actually effective, even if it's not a war crime, just because you have a deprivation of life, and therefore the state which has taken that life needs to justify that deprivation of life on a pretty compelling basis. So this does end up being successful in lots of circumstances. An important thing to note, though, is that these lines of occupation cases are somewhat limited because the European Court of Human Rights has very limited extraterritorial jurisdiction. So technically, if a crime occurs on the soil of a country which is not part of the convention, so the ECHR, which is what the European Court of Human Rights ends up deciding upon, then you will get this kind of circumstance in which you have no right to prosecution, unless you can demonstrate that there is some kind of compelling grounds by which that country has created jurisdiction. So this happens oftentimes through having effective control of a country or exercising public powers. So in some cases where countries have intervened in Iraq, like the UK, when they had performed functions that were basically the same as that of a public authority, they, for instance, had controlled some degree of local administration, decisions that they made, which ended up killing civilians, ended up being found to be admissible within the European Court of Human Rights. But that was only because they're exercising public powers. So big takeaway, if a member state or a high contracting party, I use these terms interchangeably, the proper one is a high contracting party. If a high contracting party within the European Court of Human Rights ends up filing a complaint against another party who is part of the European Court of Human Rights, that will typically be successful if legitimate. If this happens outside of the territory of the European Court of Human Rights and it's extraterritorial in entirety, then you're going to get a circumstance in which typically you won't have a finding of liability unless there's an exercise of public powers. So that's kind of the divide. I hope that makes sense. Okay, and I'm going to check for any more questions in the Google Sheet, and if not, then I'm going to wrap up with a conclusion. Sorry, it's taking a second to load. Give me one moment. Okay, great. So that looks like everything. Thanks everyone for bearing with me. I'm a bit tired this morning, so it's a bit rambly, but I hope that you got everything that you wanted from the lecture. Some important takeaways. There's always a divide that exists between national sovereignty and global authority. And this means that regional and international courts will always have to mediate their doctrines to a certain extent and reduce effectiveness to have compliance. But at the same time, to have any bite, they need to have some degree of effectiveness, and therefore they will find ways around all the restrictions that they place upon themselves, like direct effect, extradition, etc. And these courts are really, really valuable and important parts of the international order because they do govern quite a lot, and they're relevant to lots of debates about human rights, equality, discrimination, and about compliance with the EU in general. So those are kinds of the big themes. I hope that's useful for the various debates that you might encounter these issues in. And if there are no other questions, then I think we're good to go. Okay, fantastic. Thank you, everyone.